Except as otherwise provided in Section 76C of this title, a court of this state may not modify a child's custody determination made by a court of another state unless a court of this state has jurisdiction to make an initial determination under paragraph A or B of subdivision 1 of section 76 of this title, and 1. The court of the other state determines it no longer has exclusive continuing jurisdiction under section 76A of this title, or that a court of this state would be a more convenient forum under section 76F of this title, or 2. A court of this state or a court of the other state determines that the child's parents, and any person acting as a parent do not presently reside in the other state.
Basically what this is saying is that New York cannot modify Colorado's custody order unless New York has jurisdiction to make an initial determination and Colorado determines it no longer has continuing exclusive jurisdiction, or that New York would be a more convenient forum, or a court of New York or Colorado determines that the child, the parents, and the PLR do not presently reside in Colorado. So no matter what, you need New York to have jurisdiction to make an initial determination. So you need that. So that's A. And then you need either B or C. B is that the Colorado court determines it doesn't have jurisdiction anymore, or that New York's more convenient forum, or C, you could have. So then in that case, you have to have New York has the jurisdiction to make the initial determination, and New York or Colorado determines that the child, the parents, and the PLR do not reside in Colorado.
Okay. 580-611 modification of child support order of another state. After a child support order is registered, New York State may modify the order if the following 3 requirements are met. 1. Child, obligee, and obligor do not reside in New York State. And 2. Non-resident petitioner seeks modification. And 3. Respondent is subject to personal jurisdiction of the tribunal in New York State, or the child or one of the parties is subject to New York State jurisdiction and the other party's consent.
76-A, Domestic Relations Law. Continuing exclusive jurisdiction. Except as provided in 76-C, a court of New York which has made a child custody determination has exclusive continuing jurisdiction over the determination until A. New York determines that neither the child and one parent, nor the child and person acting as a parent have a significant connection with New York, and that substantial evidence is no longer available in New York concerning the child's care, protection, training, and personal relationships. Or 2. B. New York or Colorado determines that the child, the parents, and any person acting as a parent do not presently reside in New York. New York, when they made a child custody determination and does not have continuing exclusive jurisdiction under the section, may modify that determination only if it has jurisdiction to make an initial determination under 76 of this title. And I would like to apologize for the terrible, annoying music in the background.
Generally, oh wait, where am I? I didn't even, okay. 580-205, continuing exclusive jurisdiction. Generally, the Family Court of New York State has continuing exclusive jurisdiction over a child support order which it has issued. 1, as long as it remains the residence of the obligor or the individual obligee or the child. Or 2, until the individual parties file with the court consent for a tribunal of another state to modify the order and assume continuing exclusive jurisdiction.
So under Article 5B UIPSA, New York has to forward 3 copies of the petition to Oregon to Family Court or their support enforcement agency.
A support order or income withholding order of Oregon, I think, may be registered in New York State by sending the following to the appropriate tribunal in New York State. 2 copies, including 1 certified, of all orders to be registered. 580-602, procedure to register an order for enforcement. A support order or income withholding order of another state may be registered in New York State by sending the following to the appropriate tribunal in New York State. 1. Letter of transmittal to tribunal requesting registration and enforcement. So that would be Oregon requesting it. Okay. 2 copies, including 1 certified copy of all orders to be registered. And 3, sworn statement showing arrearages. And 4, name and address of obligor, and if known, obligor's address and social security number. Which, who wants to give their social security numbers out anymore? B, name and address of obligor's employer and any other source of income of obligor. C, description of obligor's property in New York State not exempt from execution. So go back to CPLR to find out what that is.
52.
And 5, name and address of obligee and agency or person to whom support payment are to be remitted.
77-D, registration of child custody determination. A Colorado custody order may be registered in New York with or without a simultaneous request for enforcement by sending to New York Family Court 1. A letter or other document requesting registration. A letter or other document requesting registration. 2. 2 copies, including 1 certified, of the determination sought to be registered. And 3, a statement under penalties of perjury that to the best of the knowledge and belief of the person seeking registration, the order has not been modified. And 4, name and address of person seeking registration and any parent or PLR who has been awarded custody or visitation in the determination sought to be registered. This name and address thing does not apply if the person was like a DD victim and says that they're gonna, be unsafe, or if they resided or have resided in a DD shelter.
I think that's in 5 though.
77-J, warrant to take custody of child. 1. Upon the filing of a petition seeking enforcement, the petitioner may file a verified application for issuance of warrant to take custody of child if 1. Child is at imminent risk of suffering serious physical harm, or 2. The child is at imminent risk of removal from this state. 2. If the court, upon testimony of petitioner or other witness, finds one of those things, it may issue a warrant to take physical custody of the child. Except in extraordinary circumstances, petition must be heard on the next court day after a warrant is executed. Any adjournment for extraordinary circumstances shall not be for more than 3 court days. The application for the warrant must include the statements required by sub 2 of section 77-G, and it must 1. Recite facts upon which the conclusion is based. 2. Direct the cops to take custody of the child or protective steps. And 3. Provide for placement of child pending final relief. 4. Respondent must be served with petition, warrant, and order immediately after the child is taken into their physical custody. 5. A warrant to take it's enforceable throughout the state. If there's a less intrusive remedy is not effective, it may authorize law enforcement officers to enter private property in order to execute the warrant and take custody of the child.
Holy shit. It's really long.
Circumstances of the case and necessary for protection of the child, the court may authorize the cops to make a forcible entry at any hour. And last but not least, 6. Court may impose conditions upon placement of a child to ensure the appearance of the child and their custodian.
Okay, 580-305, duties and powers of a New York State responding tribunal. Duties and powers of a New York State responding tribunal, 580-305. The court may issue and enter a warrant in any local or state computer system for criminal warrants for an obligor who has failed to appear.
Special rules of evidence. So there's a bunch of special rules of evidence that Dorothy's going to tell you about, but the one I'm going to tell you about is copies of bills for testing for parentage, so basically a paternity test, prenatal, postnatal health care of mother and child, furnished to the adverse party at least 10 days prior to trial, are admissible in evidence to prove the amount of the charges billed and that the charges were reasonable, necessary, and customary.
Okay, special 580-316, special rules of evidence and procedure. A, special presence of petitioner in a New York State responding tribunal is not required. B, verified petition affidavit, document complying with federally mandated forms is admissible in evidence if given under oath by party or witness residing in another state. Among the special rules of evidence and procedure is the rule that privilege against disclosure of communications between spouses does not apply in a proceeding under this article, which means that they can testify against each other. Is that right? Okay. Electronic testimony is authorized. Adverse inference may be drawn if party refuses to testify due to self-incrimination.
Here in sub F, it says, in a proceeding under this article, New York shall permit a party or witness residing outside the seat to testify under penalty of perjury by electronic means or by phone at a designated tribunal or other location. New York shall cooperate with Oregon in designating an appropriate location.
Reasonable efforts to prevent the need for removing the child from its home need not be made if A, parent has subjected the child to aggravating circumstances. B, parent was convicted of any crime listed in 358A against the child, which is oh my god, where is the list? Something with murder and manslaughter. Oh, here it is. Okay, when the parent was convicted of voluntarily attempting or soliciting or facilitating or guilty of actual murder in the first degree or manslaughter in the first degree, and the victim was another child of the parent. Okay. So again, reasonable efforts to prevent the need for removing the child from its home need not be made if A, parent has subjected the child to aggravating circumstances. B, the parent was convicted of any crime listed, which is like the murder and the attempted and manslaughter against the child. C, parental rights to the sibling of the child have been involuntarily terminated. Those three things are true. Okay. At a permanency hearing, court shall determine if the child should be 1, returned to the parent, 2, referred for legal guardianship, and 3, placed for adoption or placed in another planned permanent living arrangement. Four, an order of placement shall include, if the child is at least 14 years of age, an order for services to assist the child to make the transition from foster care to independent living. The following are deemed orders of disposition and appealable. Order 1, order denying the petition filed by a social services official, and 2, order granting petition filed by the parents for return of the child. I just did like a couple
More, okay.
The following are deemed orders of disposition and they can be appealed. And they are 1, if there's an order denying the petition filed by a social services official, and 2, an order granting a petition filed by the parents for the return of a child. Both of those can be those decisions of those orders can be appealed.